Well, good evening, everyone, and welcome to tonight's webinar. This is Planning Ahead Estate Planning Workshop. I would like to introduce you to our guest. This is Bhavik Patel.
Thanks, Sandy. And hi, everyone. So today we're going to talk about estate planning. I know I give a lot of workshops at the ARC, and a lot of them deal with public benefits very specifically, or a lot of them deal with special needs trust very specifically. And all of those things are very important topics, obviously, but also estate planning for you becomes very important to talk about because if you don't get your estate planning in order, you could jeopardize all these other things like public benefits for your loved one with a disability or failure to fund the special needs trust properly and all of those types of things. Now, even though today's topic is estate planning, and I have a slide, I will share the screen in a second. It's important that I interweave into the presentation things about public benefits eligibility, things about special needs trusts. And we'll even go off in a tangent and we'll talk a little bit about public benefit eligibility and the rules. Because if you can't, it's just so important to understand that. And I guess by way of background, I've done so many of these for over a decade with the ARC. I kind of forget to introduce myself. So I'm Bhavik. I am an attorney here in St. Louis. My uh, specialty, expertise is in special needs planning, estate planning, public benefit eligibility, in sort of that whole bubble is everything that I do in as a practicing lawyer. So let's talk about estate planning for a moment. As hard as it may be, let's focus on you, those that are here, the moms and dads, the parents, the grandparents, the brothers and sisters. And let's make sure that you understand the importance of an estate plan for you. Because if we don't address that, as I said, and you'll learn today, there is an unintended consequence that could have significant and adverse impact or benefits for your loved one. One more thing I'm going to qualify. Um, Instead of saying your loved one with special needs or your loved one with a disability or your child with a disability, I am going to just have this discussion today and I'm going to call that person Joey. So when you hear me talk about Joey, it's a way to personalize it. It's a way to kind of just shortcut it a little bit. Of all the families that come and see me and talk about estate planning, what are some of those reasons? What are the reasons and what are the things they're trying to solve? And though there may be many of them, I have kind of deduced it to five broad categories or five major or common used reasons why people want to get an estate plan. And then the format of this presentation is going to be taking each one of these five reasons and kind of educating you on what happens if you don't do an estate plan and what are those consequences and what types of estate plans may be a good way to solve for that specific reason. So, as you can see on the screen right now, the five reasons, just as a broad overstroke, planning for incapacity. We're not just talking about your incapacity, but we're also talking about Joey. And so we need to plan around those types of situations. A second is avoidance of probate, which all of these things I will uh, dive into a little bit deeper later. The third is planning for the proper disposition of your estate. Uh, those are fancy words. That really is talking about who gets what, when who dies when, and how. And what safeguards do we need to put around it so that Joey doesn't lose benefits or Emily, Joey's typical developing sister um, has the proper guardrails to make sure she's taken care of. Estate tax planning is another reason, and creditor protection. For today's presentation, I'm really going to spend most of my time and energy talking about these top three: estate tax planning and creditor protection. I'm not going to really talk too much about it. What I'll do is just give you a very broad overview right now before I dig in. Estate tax planning. Currently in the state of Missouri, assuming everybody here is in Missouri, um, Missouri doesn't have an estate tax, but we do have a federal estate tax. And on federal estate taxes, it's a pretty large threshold. So that's why I don't spend a lot of time talking about it. Current law, a husband and wife in total have the ability to pass on nearly $26 million before they have to worry about estate taxes. If you're not married, it's 13 million that you could pass on to the next generation without worrying about estate taxes, which is why I don't really spend a lot of time and energy talking about that in this context. The other one is creditor protection. Let's just suffice it to say, if you put a proper estate plan together, there is a way to leave your assets to your loved ones, Emily and Joey, in a way that protects that inheritance from what could go wrong in Emily and Joey's life. And what I mean by that is creditors, liabilities, judgments, and maybe or most relevant, divorces. If you're if Emily was to get married and divorced, the inheritance that you were leaving for Emily, we would like to make sure is protected so it doesn't go to the ex son in law. Um, again, we're not going to talk a lot about that today. In fact, that's probably all I'll talk about for that. If you have questions, I'm more than happy to answer. But we'll focus on the first three of these reasons. So let's talk about planning for incapacity. First, let's talk about your incapacity. Here's the general rule I want you to know. No adult is allowed to automatically have another adult make their medical or financial decisions for them. So, what does that mean? So, I'm married. My wife's name is Priel. If I didn't have an estate plan in order for me, if I didn't do anything, and nothing in place, if I, for some reason, became incapacitated tomorrow, car accident, mental illness, whatever the case could be, my wife would have no authority to make any medical decisions for me. My wife would have no authority to make any financial decisions for me. In fact, my wife and I own our house together. We're both on the deed. We both own it. If I became incapacitated, my wife would not be able to make any decisions regarding the house, even if that meant selling the house, uh, mortgaging the house, whatever the case may be. She would have zero authority to do it, even though she owns it. So this is a major issue because inevitably, I think last time I looked up the statistics, I think it was about 68 to 70% of all adults will at some point in their life become incapacitated, whether it's Alzheimer's, dementia, whatever the case may be. So, no planning at all. If you don't address it, the only way my wife would be able to make those decisions for me would be to have to go to court and proceed on with a proceeding either called a conservatorship or a guardianship, and most likely both. So, a conservatorship is a court process a very tedious, painful court process in which somebody is applying for the court to approve and give approval to deal with my financial part of my life. A guardianship is yet another court process in which my wife would be trying to get approval from the court to deal with my medical. So the difference between those two words, conservatorship and guardianship, is one's financial and the other is guardianship. Now, applying this to Joey, if Joey is not yet the age of 18, moms and dads already have the automatic and legal authority to make decisions. In fact, it doesn't even have to be Joey, it could be Emily. Anyone under the age of 18, moms and dads have the legal authority to make medical and financial decisions for them. But once Joey turns 18, and if he is not capable of making sound medical and health related decisions for him, moms and dads, if will have to go and consider a guardianship or a conservatorship to be able to get that authority. Now, some people, that is the only route that they can go because Joey has no question, he's not in the gray zone, so to speak, in terms of his capability of making decisions for himself. A big part of the population's in sort of the gray zone where Joey might be able to have an independent life, might be able to make decisions for himself, but we don't know yet. It's too early to tell, or we need more time of development for us to really know. And so there may be a reservation, so to speak, on going ahead and seeking these types of court processes like a guardianship. What can be done for you and what could be done for Joey if Joey's in the gray zone? There's some planning opportunities. So I'll go ahead and jump to the question first, and then we'll go to what the planning opportunities are. One of the questions that was just asked was, so if you do not have a power of attorney in place when an accident happens and you have to get a conservatorship or a guardianship, it sounds like. In an emergency situation, do those processes get fast tracked? Or they're as slow to complete in emergencies just as they are for regular non-emergency conservatorships or guardianships? What happens to those necessary decisions then while you're held up in the court process? What a great question. And I can already glean from the question that someone's had some experiences here. If there is a true emergency, a life and death matter, or a significant financial harm matter, there is a process in court where you can seek an emergency guardianship or an emergency conservatorship, which can happen in matters of a day or two. So that would be the likely process if it truly is an emergency. So hopefully that addresses that question. Let's talk about what can be done because that question kind of jumps to it a little bit. The most effective way to deal with your incapacity while you're here now and you don't lack capacity is proactively preparing what is called a power of attorney. And there's two types. There's one for healthcare and there's one for financial. Both of these documents are very form-like. They're not complicated. They're not expensive to do. They're very simple. A lawyer can get these to you very quickly. And the power of attorney names agents that will, and you can name multiple agents, or you could name a list of agents in successive order to be able to make your medical and make your financial decisions for you. If you have that in place, you get to avoid, and I can't even begin to stress to you what you need to be hearing from me in general, and what you probably already can glean is you want to avoid court processes if you can. There's nothing efficient about that process. As much as it's important, it's invaluable. It takes hiring a lawyer, it takes a lot of money, and it takes time. So there could be, even in an emergency setting, it's going to cost you a lot of money and legal fees and other things to have to deal with it. So if we can be proactive, it's way better than being reactive. I would highly encourage every adult that has capacity. So this could apply to Emily as well, who might be a 20-year-old in college. Think about all your moms and dads, their daughter Emily, and my hypothetical family that I am talking through. Um, if they're an adult, they should have a power of attorney, and they should name who is going to be their decision makers if they can no longer be their decision maker for themselves. Huge, huge impact in terms of making sure things happen easier. Uh, just to give you context from a dollars and cents perspective, going to court is not cheap. So, getting a guardianship, getting a conservatorship in court, these things can cost easily two, three, $5,000, and then there may even be some ongoing legal fees. Um, these powers of attorneys cost like $250 with a lawyer that knows what they're doing. That is definitely a planning technique. And it's one that I think should apply to every single adult in the universe, personally, um, regardless of what their net worth is. A couple of other things I want to just point out. You may want to also consider creating a living will. And by the way, a living will can be embedded inside the same document as the healthcare power of attorney. What a living will is it's a expression of your wishes that at some point in a very narrow scenario where you're at the end of your life and the medical determination is that you really have no viability and your situation is not reversible, that you wish to not artificially prolong your life. That's a very important document to have, or uh, a desire to express and iron out. And the reason is because it could be a huge drain on your financial assets if you're staying, uh, for lack of a uncouth way of saying it, plugged up to a machine, and that hospital bill um, racks up. And what a lot of people don't know is health insurance often has a cap. So there, and that cap can be reached very quickly if you're plugged up to, to a respirator in a hospital for several weeks. So it could drain the assets that you're intending to leave to your children if you don't address that issue. So there's a financial angle to it that I kind of wanted to relay. Um, Long-term care and disability insurance. If you have the capability and the cash flow to be able to pay for this, this is a tremendous tool. As all of us at some point are going to get older, and the likelihood of us needing long term care in a nursing home or something like that could be strong. And we may have worked our entire lives to create a nest egg for ourselves and for our loved ones, if it all gets expended because of our nursing home care or our long-term care, um, you know, it would be a financial drain for the support you're wishing to provide for Emily and Joey. So I often it's not right for everyone, but I do encourage you to look into. I'm not a financial person. I'm a lawyer, but I encourage you to talk to a financial advisor or somebody to kind of address what that looks like. How much does it cost? What kind of coverage do you get? Those types of things. The last thing I'll say about it on this slide is a revocable trust. By creating a trust and putting your assets in it, if you became incapacitated, your trust documents would have a backup trustee that would be able to manage everything for your care, for your needs. And it's another way to avoid having to go to court. There's a question that says, is there a benefit to having an irrevocable trust? Uh, maybe is the answer without any details, without knowing specifically what's driving that question. The answer is, yeah, maybe. But a revocable trust is more than sufficient for dealing with this need. An irrevocable trust, I would say, might be a useful strategy for dealing with people that don't want to pay for estate taxes, which we talked very briefly about, or someone that wants to do some what we call elder law planning, where they have worked their entire life to create a nest egg. Let's say they have $1 million and they want some of that to guarantee to go to their kids versus nursing home care. And so they might move some of it into an irrevocable trust, but then they have to wait. The rule is 5 years before Medicaid could help them with their nursing home care. That's a elder law. It's another unique subset specialty that's worth a conversation if that's what you're interested in. But otherwise, outside of those two things, there's really not a lot of significant reasons to do an irrevocable trust. I guess another one might be creditor protection, which again, I talked about broadly. It's not something I'm going to spend a lot of time talking about. Let's talk about avoidance of probate. As we talk about probate, let's talk about what probate is. Probate is a court process that deals with the passing of a deceased person's assets to whoever is the next legal owner of those assets. Here's a few things that are problems with probates. One, it takes a long time. Probate, the average probate takes 12 to 18 months. That's the average. So some can be done a little bit sooner, and some definitely can be done longer. I've had probates that have lasted 6 or 7 years. So there can be a long time before those assets actually can be utilized by whoever they were intended to go to. Two, probate's very expensive. The only people that benefit from probate are the lawyers, if I'm going to be honest. And it's not one that I'd ever like to be benefiting from. We really want to avoid probate. I've actually never met anyone that wants to go through probate. A third, probate's very public. So your nosy neighbors can understand everything about you and your universe. That might be your assets. That might even be your business. You might be in business with a bunch of partners. Well, your partners certainly didn't want information about your business to be public to the competitors. But if you go through probate because one of the partners dies, it's all public. And all the valuations of businesses, other assets, all of that is part of the probate process. So it's a lot of information and a lot of cost, like I said, that ends up getting incurred when you deal with probate. And the last thing is the court's involved. The court's involved. The court has to maybe approve certain things. So these are the reasons we want to avoid probate. And if you don't plan to avoid probate, that's what's going to happen. What are the ways we can avoid probate? There's a lot of ways. Some of them don't even require a lawyer. Let me give you an example. Jointly held property. So if my wife and I own the house together, I die, it automatically goes to my wife. It avoids probate. Um, there are instances I just want you to be aware of when we talk about the special needs world. We don't want Joey to jointly own property with me because that jointly held property is going to count towards Joey's assets. And that could cause him to be disqualified from receiving public benefits such as Medicaid or SSI. So that's a problem. Also, jointly held property, like if a parent and a child own a checking account together, that asset is vulnerable from any judgments or creditors that could occur from either of the account holders. So, me or Emily owning that account together, if Emily got divorced, that joint account is subject to a marital division. So, there's a lot of exposure to jointly held property, though it does avoid probate. So, I just kind of want to make sure you hear that. A beneficiary deed avoids probate. This is a very effective strategy for your home or real estate. You can own your real estate. I can own the real estate in my name. I can file a beneficiary deed with the Recorder of Deeds office that says where my home goes when I die. Um, Obviously, you're going to need a lawyer to create one of these beneficiary deeds, but they're very inexpensive, maybe $250 to $500 to create one. And it does successfully avoid probate. The issue with like the Joey context is I don't want to leave the home to Joey because Medicaid can attach a lien on it when Joey dies. So I would rather leave the property into a special needs trust for Joey because then Medicaid can't touch it. As just a example. And we'll talk more about that later. Um, every single titled account can have something called a TOD or a POD or a beneficiary designation on it. A bank account, a business interest, um, 401k, a life insurance, an IRA, they all get to have these beneficiary designations as long as you do it. And that does leave it to whoever you named in a way that avoids probate. Now, you can't name Joey because if you leave those assets to Joey, that would be an accountable resource that would disqualify Joey from public benefits. But you could TOD it into a special needs trust as way of an example. The most comprehensive way to avoid probate and to address all the unique elements of how you want things to go to people is a revocable trust where it answers, yeah, when I die, I want my assets to split between Emily and Joey. And I want Emily's to go in a bucket where she has someone overseeing it for her until she reaches a certain age, by way of an example. Because Emily, in my example, is 20, and I don't want $1 million to go to Emily while she's in college. I want her to finish school. I want her to get a job. I want to pay her tuition. I want to do this. I might want to get her a car. Might want to get her a place to live. That's stuff that the gatekeeper can do for her But then when Emily's 25 or 30 or whatever age makes sense to you, maybe at that time she doesn't have to ask permission of the gatekeeper. Those are all things that can be addressed in a revocable trust. A revocable trust can also say, hey, the other half that didn't go to Emily is going to go into a special needs trust for Joey. This is a way where that's why I say it's very comprehensive. It's a way to make sure everything is going where you want it to go in a way that maintains sort of uh, public benefit eligibility for Joey, but also sort of guidance for Emily so that she can continue to march on in the things that she needs to develop in her own regard. Special needs trusts. Creating a special needs trust, as you've already heard me say a couple of times, is definitely a way to leave assets for Joey without disrupting his public benefit. Thoughts on creating a special needs trust via a revocable living trust or doing a standalone? That's a great question. Here I've done this so much that I have almost summarized this to one singular question. The question I would ask is it possible that Joey receives money while I'm still alive? If the answer to that question is possibly yes, I really think you need a standalone special needs trust, one that's ready to receive assets at any time. That's what standalone means. It means it's created and it's ready to receive assets no matter when. If the answer to that question was very unlikely no, then I don't think you need a standalone special needs trust, and we can embed it inside your revocable trust, which is called a testamentary special needs trust, which means created upon the death of mom and dad. And so your trust after mom and dad died would then grow a special needs trust to receive that inheritance that maybe you are planning on leaving them. Can a special needs trust be revocable? Is another question. Um, uh, the answer to that question is yes, technically, but I would never do it. Without getting overly complicated, there is significant downside to having a revocable special needs trust in terms of um, what I'm going to call accountable resources to Joey. Uh, if properly drafted, it should create enough flexibility as you could possibly need to make it irrevocable so you don't have that downside. The last reason I'm going to really highlight is planning for the proper disposition of your estate. And what happens if you don't have an estate plan at all? If you don't have an estate plan, then the state of Missouri has created one for you. And suffice it to say, it's not what you want. So if I died today, and I didn't have an estate plan, half of my assets would go to my wife. The other half would go to Joey and Emily. The problem with that is it would go to Joey and Emily. And so for the piece that went to Joey, that would be an accountable resource that would disqualify him from public benefits. The part that went to Emily, depending on how old she is, if she's under the age of 18, that would have to actually go through court, and we'd have to have a conservatorship. If Emily was over the age of 18, she'd get free and unrestricted access to whatever that money is, however much that money is, for her to do whatever she wants, including blow it or subject it to a future divorce or gamble it away at the roulette wheel. You know, so it's not an ideal scenario to let the Missouri rules apply to you. What are things that you can do with a proper estate plan to deal with the disposition of your estate? Well, one is you can govern how it goes to your spouse if you want to make restrictions on that or not. Most people don't, but we could have a situation where we have a spendthrift. Uh, if my wife passed away and I liked gambling and she didn't put any restrictions on me, I could take that money and I can blow it all, which means it's not going to be there for the kids. Um, these are outlier situations and one-offs, but I mean, most people, I think it could go to your spouse and it'll be all fine. But if your family dynamics is of the nature where we need to monitor that or we need to restrict it or safeguard it, then this is what an estate plan will allow you to do. Planning for minor children. Well, you want to leave, and adult children for that matter, Emily in this example. We want to be able to leave our inheritance to our children, whether they're children or adults, in ways where we're not um, having to go to court, that in a way that we're not causing bad behavior or lack of proper incentives or lack of proper motivation. Frankly, it's kind of a way to parent from the grave. We might need a gatekeeper to oversee it. Um, a question that was just asked was, if you already have an estate plan, would you have to start over with a new plan or would you just edit your current plan? Yeah, most estate plans can be revised or modified or amended. So you don't have to start all over. You could tweak it to fit certain needs, whether it's to add a testamentary special needs trust or whether it's to add appropriate guardrails around what's going to Emily. Um, yeah, you really won't need to start over. I shouldn't say that blanketly. I mean, if the documents are just not at all what they need to be, you might need to start over. But generally speaking, it's usually done by modification or amendment. Planning for disabled beneficiaries, which we've talked about, whether we need to leave the inheritance in a special needs trust. Those are all things that we need to contemplate in terms of doing your estate plan. We also need to evaluate planning for particular assets. There are unique assets that require um, particular attention to it. Retirement accounts, for example. Uh, we leave the retirement accounts to our spouse that allows for maximum income tax deferral. If we were not to leave it to the spouse and we're going to leave it to the kids, that might result in more taxation. Maybe that's the right thing, but we need to talk through it. There used to be the law, it's changed. It changed when the Secure Act was passed in 2020. But prior to 2020, you got to leave your retirement assets to um, your non spouse in a way that it got to continue to grow tax deferred for that individual's life expectancy. So I could have left my retirement accounts to Emily in the age of 20 and her life expectancy is 86, and then she got to stretch and continue to grow that money tax deferred, and she would only have to get small required minimum distributions that were required by the IRS tables. Since 2020, the law changed. They got rid of required minimum distributions for Emily, and they said, you know what? You can continue to grow that money for 10 years. But no matter what, after 10 years, you got to take all the money out. And then it's going to hit a huge income tax liability whenever she pulls the money out. Now, she could pull the money out 1 year, 1 year, 1 year, 1 year, 1 year, 1 year over the 10 years, or she could let it grow and then pull it all out in 10 years, or she could take a big amount of it in year one and then another amount in year 4 and then the rest of it in year 10. So it created some flexibility, but it did create a finite timeline as to the growth of that retirement asset tax deferred. One exception to the rule is if you leave the assets in a special needs trust for Joey, Joey doesn't have to take it all in 10 years. He can stretch it out over his life expectancy. So the caveat to the rule is there is still a required minimum distribution for special needs children or beneficiaries. So that's very particular. And it very much could change the strategy of what you're leaving Emily versus what you're leaving Joey. But that's why I'm addressing. There's particular assets that are unique. Real estate is another one. Who's going to use it? How's it going to be repaired? How's it going to be upkept? Should it be sold? Should it be turned into a rental property for cash flow? Should we put that in a business, an LLC, so we protect ourselves while we're making that cash flow? Lots of questions. There's even 10 more I could think of that deal with that. We have to address special assets as part of your estate plan. Missouri's law doesn't address any of that, which is what is the problem with no estate planning. Okay, I told you I would start talking about public benefits. So I'm going to pivot right now, and I'm going to give you a little bit of a very broad stroke of understanding eligibility for public benefits. I give a couple of other workshops that just talk about public benefits that get a lot deeper into the conversation. This was about estate planning, but I don't think any family with a child like Joey can ever not hear this as many times as possible to fully grasp the consequences. So let's talk about benefits. There are two broad categories of public benefits from my perspective. There are benefits that are not based on financial need. So that's good old fashioned Medicare or good old fashioned Social Security or special education. But there is the second category, which is benefits based on financial need. And those are Medicaid. Those are SSI, which we'll talk about in a second. Those are Section 8 housing, food stamps, things like that. But what is SSI? Well, first of all, let's get terminology right. SSI is called supplemental security income. SSDI is social security disability income. They are vastly different things. SSI is a federal program, which means funded by the federal government but it's administered at the state level. And if we were live, I would say what that really means is utter chaos, and you would laugh and chuckle about it. Since it's not interactive, I sound crazy saying it, but that's the joke. Um, but in any event, SSI requires the proof of two things. One is sufficient evidence of disability. Let's suffice it to say you're on this call with enough of that criteria being met for Joey. So the second thing is really the thing I want you to hear today is that Joey must establish financial need. We'll talk about the test in a second, but whose financial need do we need to look at depends on how old Joey is. If Joey is under the age of 18, financial need and the test for that must be met not only for Joey individually, but for mom and dad as well. If Joey is over the age of 18, then we can look at Joey's assets in terms of whether he passes the financial need element. I have a question. I'm not sure I understand it yet, but let me read it out loud. Let's say that Joey goes over the financial limits for some of these programs. Would they be permanently excluded, or could they transfer assets to a special needs trust and then qualify again? Great question. I'm going to answer it very shortly now and much more elaborately through the rest of this presentation. If Joey is above the threshold, he's disqualified, not permanently, just until he can requalify. However, if he just gives the money away to try to qualify again, that triggers a 5-year look back period. So we never want to do that. Now, the question was very specific to, can Joey put it in a special needs trust? The answer is yes, but it's a particular type of special needs trust called, my words, a Medicaid payback trust, which means Medicaid can attach a lien to those trust assets so that if Joey passes away, the first person that gets paid out of that trust is Medicaid. So it's not the ideal strategy. But I understand the question was, if he already had money beyond the limits, what can you do? And I'm going to talk about that a little bit later about options. So it's a short answer to the question, but the rest of the presentation will answer it in more depth. Something that you need to know about SSI. It's restricted money. SSI, if Joey qualifies, he's going to receive money monthly from $0 to around $850. I'm rounding. I'm not being very specific, but that's generally the range. But it's restricted. Joey can't do anything he wants with that money. It has to be used for very specific purposes. In particular, it needs to be used for Joey's food and shelter needs. We'll talk a little bit more about that in a second, too. If there's anything I can impart on you today that I want you to really, at a very simple baseline, understand, it's what I'm about to talk about. There are two different tests that you deal with the eligibility of SSI: the income test and the resource test. I'm gonna give you a silly analogy that I hope you can kind of close your eyes and visualize, because this can be very confusing stuff. And I hopeful that I'm going to explain it to you in just the most simplest way for you to understand it. The first test that we need to um, surpass is called the resource test. That's the real financial need element that I addressed earlier. So Joey has to pass the resource test in order for the door that's in front of him to unlock. The other side of the door is public benefits, in particular SSI and Medicaid. We must pass the resource test before we can unlock the door. Otherwise, the door is shut and there's nothing on the other side we can get. Once we pass the resource test, then we get to look at something called the income test to kind of figure out how wide the door is going to be open. I said a second ago, SSI can be anywhere from $0 to $850. Well, zero, the door is shut. The door is completely open is $850. And anywhere in between is where the door could be hovering based on the income test. Let's talk about the resource test for a second. Before we talk about the resource test, we really need to understand what a resource is. And here's where I want you to start with the analysis. Anything that can be converted to cash, let's consider it as step one as a resource. So that's anything. Anything can be converted to cash, whether it's a penny or whether it's $1 million. Regardless, all of it is a resource. What's the test criteria? For SSI purposes, the resources for Joey, or if Joey's under the age of 18, Joey, mom, and dad, cannot exceed $2,000 in value on the first day of the calendar month in which Joey applies for benefits. So today is February 13. If Joey applied for benefits, they will go back to February 1 to see what Joey's resources are. If it's discovered that Joey gave money away back to mom and dad, then they can go back 5 years to see what Joey's assets. We do not want to do that. That transfer of assets to become eligible in the wrong way is called, it's an actual legal thing. It's called transfer in fraud of Medicaid rights. And it can be a stiff fine and it can be also imprisonment. So we don't want to mess with that to try to qualify. For Medicaid, the screen that you're looking at says 4,000, but it is closer to 5,000 at this very moment for Medicaid. I almost want to eliminate that from the slide because the only number I want you to think about is the lower of the two numbers because that's a safer way to do it. So I only want you to think of 2,000, even though that's technically not correct. I want you to always only remember the resource test being $2,000. I don't want you to even think about the 5,000 for Medicaid. Resource test 2,000. That's my ask. I have a question here. So So is it Joey's resources or referring to parents' resources as well? Is the question. Good question. We talked about this briefly. Um, it depends on Joey's age. If Joey's under the age of 18, we're talking about Joey and mom and dad's assets. If Joey's over the age of 18, then we're very much specifically talking about Joey's assets. It is not easy to qualify for public benefits prior to Joey turning 18 because it includes mom and dad's assets to the 2000. And if where I'm asking you to start is anything can be converted to cash, then we're talking about everything. And being less than $2,000 is not very common or easy to meet that test. The reason we keep talking about SSI eligibility is if you can qualify for SSI and meet the resource test for Medicaid of 5,000, you'll get to qualify for Medicaid. So it's all the same test. Okay. Um, so I asked you to remember I asked you to start with anything as a resource. Now the law isn't that cruel. It excludes a few things. What I'm about to go through is a couple of slides. That's an exhaustive list of what's excluded. So if you don't hear me say it, it is not excluded, meaning it's part of the resource test. So only the things I'm about to share are excluded. A home that Joey owns, in which he lives in, can be an excluded resource, even though it's an excluded resource that could allow Joey to receive benefits. I want to be very clear. Do not leave the home to Joey, because the moment he can't live in it, it's going to disqualify him from public benefits. And the moment Joey passes away, that asset can't go to other family members. It's going to have to be sold. And then it's going to have to pay Medicaid back for every amount of dollars Medicaid spent on Joey. So do not leave the home to Joey. But technically, if you did, it would be an exempt asset during Joey's lifetime. And as long as he lived there. Household goods altogether worth no more than $2,000 is exempt. So that's your clothes. I'll tell you, let's not focus too much on this. It's really hard for anyone to know who owns what. No one can tell. Is the iPad owned by mom and dad and they just let Joey use it? Or is the iPad owned by Joey? So I wouldn't focus too much on it, but like I said, I'm going to go through everything that's exempt, whether it's really practical or not. Another exempt asset is a vehicle that Joey drives, provided the value of that vehicle does not exceed $4,500. I don't know about you, but there's not a lot of vehicles that are underneath the value of $4,500. However, there is an exception to that limit of $4,500 if the vehicle is necessary for employment or medical treatment or for handicapped persons to be transported, then there is no limit to the vehicle. I still don't understand why you need to title the car in Joey's name. In my opinion, mom and dad owns the vehicle, Joey drives it. It's no longer a resource for Joey. Something to think about. A few more exempt assets. A life insurance policy with a cash surrender value of no less than $1,500. Term life insurance has no cash value. But we are talking about life insurance owned by Joey. It's there. It's not one that's really applicable for most people I meet with, but nonetheless, I'm giving you the exhaustive list of exempt resources. The next one's very important. It's morbid, but it's very important. A prepaid funeral for Joey is an exempt asset for eligibility purposes. The last two are newer. Well, I'm sure the next one is newer. Joey can have an ABLE account, which is basically a savings account that can grow, that can be added to no more than let's say $15,000 a year can go into it, and it can grow all the way up to $100,000. Above 100,000 is a problem, but this is a valuable tool to be able to save money in Joey's name without disqualifying him from public benefits. Here's a couple things I want you to hear very clearly. I don't want mom and dad to go put mom and dad's money in an ABLE account for Joey. The value, in my opinion, for the ABLE account is purely a rescue tool. So if Joey ends up getting money that would otherwise disqualify him from public benefits, a nice rescue tool is to take that money and put it in an ABLE account. Or if Joey's working and he's starting to accumulate assets in his job, we might take the accumulated amount and put it into the ABLE account. That way, he continues to remain eligible for public benefits, but still have a savings. Do not, if public benefits is something you're going for, do not have Joey work and put money in a 401k. Because I did not mention 401k as an exempt asset. Now, the reason I don't want mom and dad to proactively put money in an ABLE account is because Medicaid gets to attach a lien to those assets as well. So that if Joey passes away, instead of that money passing on to other loved ones, it's going to go to Medicaid. The last one, which I think you've gathered, is if you leave assets in a special needs trust, that special needs trust is not going to be looked at in terms of Joey's eligibility rules. Now, if mom and dad wants to put money away for Joey, putting it in a third party special needs trust is definitely an option. Mom and dad could also just keep it in their own name in a savings account, and then at their passing, leave it into a testamentary special needs trust. So there's options there as well. I have another question. Will Medicaid attach a lien to a special needs trust? It depends on which type of special needs trust. And I also want to say another one of the presentations I give is exclusively on special needs trusts and all the different kinds. In order to cover every topic, I'd have to be here for 5 hours today, and we cut off in about 18 minutes. So please join the other ones that talk about all those other special needs trusts. And I'm trying to be general here. So Medicaid can attach a lien if it's a Medicaid payback trust. If it's a third party special needs trust, they cannot. Now, explaining the differences to all of that, let's join the special needs trust workshop that will talk about it. But a great question asked about SSDI. There's amazing benefit that so many people are unaware of, and that is Social Security disability income. And let's talk about that very briefly. And then I want to move on to one broad other topic, and then we'll open it up for general Q&A. Remember, SSI is a financial need-based benefit. There is a benefit called Social Security disability income that is super powerful, that is not necessarily financial need-based. So what do you need to establish in order for SSDI? One is Joey must be medically determined to have been disabled prior to the age of 22, and Joey's parent must be eligible to receive Social Security. Benefits do not become payable until until the parent is eligible. And how does a parent become eligible? One of three ways. The parent is deceased, the parent reaches the retirement age and is receiving Social Security, or the parent themselves have become disabled. Social Security is not affected by the child's assets. So there's no resource test here. However, if the child is able to earn income and is earning income above a certain amount, then conclusively SSDI does not see Joey as disabled, and therefore the SSDI benefits are not allowed. That amount is roughly around $1,100. I'm rounding for simplicity, but that's around $1,100. So if Joey can work and get paid $1,100, he's not going to receive SSDI. How much can Joey get from SSDI? Depends on how the parent is eligible. If the parent is eligible because the parent is disabled or reached that retirement age and receiving Social Security, then Joey's entitled to half. So if I was receiving $2,000 from Social Security because I'm disabled or I'm retired, Joey will receive an additional $1,000. If Joey is, if I'm passed away, and then Joey will receive 3/4 of what I was getting. So if I was getting $2,000 and I died, Joey will now get $1,500 in SSDI benefit. Now look at this example to kind of tie some things together. Let's assume Helen has been disabled from birth and was receiving $720 in SSI money. But then Helen's father, Earl, retires and is eligible and has been receiving $1,000 a month in Social Security. Well, Helen, who was disabled prior to the age of 22, will now start to receive $500 a month in SSDI. But the SSDI money is perceived as income to Helen, which will close the door in the income test for SSI purposes for Helen. So she will no longer get $720 in SSI money, but instead, in this example, she's going to get $240 while Helen gets $500 in SSDI money. This is okay. I mean, you're looking at this and you're saying, well, that's $20 more than what she was getting in SSI. But the more money you get in SSDI is superior to the amount of money you're getting in SSI. Because remember, SSI is restricted money. It can only be used for food and shelter. SSI, you have to pass the resource test to be able to get. So she can't save money or she'll lose that SSI money. SSDI, however, she could have $1 million in savings and still receive SSDI. And the money is unrestricted. So it's not just a food and shelter, it could be for entertainment or anything else. So even though it's a $20 swing with the $740 in total she's getting, it's way better money she's getting. Just to talk about Medicare for a second, because I want you to be aware of this. If Helen receives SSDI for 2 years, she automatically qualifies for Medicare, which is superior health insurance to Medicaid. So I just wanted to kind of provide that. One last thing I want to just talk about from a very broad stroke. There are things I come across all the time that could cause a potential inevitable path to a disruption to financial need-based public benefits. I want you to be aware of them and I want you to understand how to solve them. The first thing is gifts to minor act accounts. So we're talking about custodian accounts or uniform transfer to minors act accounts. And I'm going to go ahead and throw in here 529 plans or most accounts. Remember, I gave you the exhaustive list of assets that are accountable resources that are excluded from accountable resources for the resource test. I never mentioned custodial accounts. I never mentioned uniform transfers to minors act accounts, and I never mentioned 529 plans. So if Joey has those types of accounts, you're walking down the path of potential disruption for public benefits, financial need-based public benefits. So we need to be really careful about creating these accounts, and we need to be very proactive on what to do if we have those accounts. How do we get them spent down? How do we maybe transfer them, not to another person, but to an exempt asset? Maybe we put them in an ABLE account. Maybe we prepay a funeral arrangement. Those types of things. So that's one. The second one is unstructured or improperly structured beneficiary designations. So we have life insurance, we have retirement plans. If you have those, all of those documents, when you got them, whether it's through your employer, the orientation through your employment, whether you've gotten separate things, whatever the case may be, wherever you got those assets, they normally present you with a beneficiary designation. And in those beneficiary designation forms, we often by default write my spouse as the primary beneficiary and my children as the secondary beneficiary. Well, if your children includes Joey, that's a problem because if you die, there's a chance Joey's going to get that asset. Joey gets that asset, it's going to close that door and lock it, making you no longer eligible for certain public benefits. That's the problem. So instead of it being Joey's name, that's where we would put the special third party special needs trust. Whether it's testamentary or standalone, requires that unique analysis. I often am meeting with families that says, well, I don't need to worry about disqualifying Joey from public benefits. I'm just going to give everything to Emily, and then Emily's going to take care of Joey, so no problem. Well, the problem is when you do that and you don't do it right, what if Joey gets married? What if Emily gets married and then subsequently divorced? Half that money that was there for Joey is now going to be with your ex-son-in-law. Or what if Emily gets in a car accident and gets in a lawsuit? Now that money is lost in that lawsuit. Or Emily has children of her own and is having trouble to make ends meet. She might just be succumb to the pressure of taking care of her own children and using that money for her own children instead of Joey. The point I'm making is it's not a good strategy. It leaves a lot of vulnerability for a safeguard of assets that you intended to leave to Joey. So much better to leave the money that you wanted to for Joey in a special needs trust and then name Emily as the trustee of it so she could still be involved. But now it's not causing all of these unique issues to subject what could be there for Joey or what needs to be there for Joey. Do not disinherit Joey. Joey's the person that needs it the most. It makes no sense to me to disinherit. Um, the next one, we've already spent some time talking about no estate planning. That means the Missouri statutes created one for you. And remember, that plan says that half goes to my wife, half goes to Joey and Emily. That's a problem because as soon as Joey gets it, he's disqualified for public benefits. So that's why no planning at all is not really an option. And the last thing I'm going to talk about is we need to be aware of whether other family members are intending to leave Joey assets at their passing or during their lifetime. Very important thing. Great thing. What a wonderful thing for Joey. It's just, we need, if that happens, we need a standalone third party special needs trust to be able to already be there, activated, to be able to receive that money from grandma, or grandpa, or Uncle Billy, so that it doesn't disqualify Joey from benefits. And I'm going to leave it for any of you for questions that you might have. A question that was asked is, so if Joey is 18 and mom and dad are 40, working and not disabled, does Joey qualify for SSDI or any type of disability income? And the answer is no. The parent must be eligible. And so why we spend so much time talking about SSI is maybe that's what you have to have until the parent becomes eligible. And then you switch over from SSI to SSDI.
Mhm.
How does respite care, therapy, or life skill training classes interweave with public benefits? I think there's a perception that wealth precludes you from advanced planning or pursuing public benefits, but don't they all kind of work together? Yeah, wealth doesn't preclude you. This is a philosophical thing, but we all pay taxes. We all fund these services. We all should get them. Unfortunately, if you don't put your planning together correctly, wealth could exclude you from getting those benefits. So we really got to put all our stuff in the right buckets so that you do get to afford yourself to these benefits. And respite care, therapy, and life skill training are all things that Medicaid can pay for, or other public benefits can provide that support that we all need. So you do want to make sure that you're not somehow excluding those types of cares and services for your Joey. And there is absolutely a way to sort of get it all. I mean, there really is. And some might be simple, some might be very complicated planning, but it's a puzzle. And I have never not been able to put a puzzle together yet. So for what it's worth, there's always a way.
And I
And
would encourage everybody on here, if you are a St. Louis County or a St. Louis City resident, the St. Louis Arc does have a respite program, our respite program. There is information on our website. as well about that. It's a wonderful program, and we can get you information about that as well. And again, that's not something that's complicated to get involved in. So we would love to share that information with you as well.
This is very convoluted stuff.
Mhm.
And if you hear it for the first time and you got it, kudos. But oftentimes you need to hear it multiple times, and I am all in to make sure you get it. So, whatever it takes.
Thank you all so much for joining us. Bhavik, thank you again. Thank you for your time with us. Thank you for being a board member. I know that that is precious time as well for you to support our agency. We appreciate that as well very much. And it was great seeing you. And thank you for sharing all of your time and your knowledge with us. We really do appreciate it.